Talk 1470, WWNN Pompano Beach, Boca Raton, Miami, Fort Lauderdale.
AM 1470, WNN, with more of what you need to know. Tune in for No Bones About It with Dr. Alvin Stein, Tuesday mornings at 11 on South Florida's Health and Wealth Network, AM 1470, WNN.
If you suffer from excruciating back pain and sciatica, pay careful attention. According to a study in the medical journal Spine, back surgeries to alleviate pain frequently backfire, leaving patients in more pain than before the surgery. A second study from the University of Cincinnati's College of Medicine provides clear evidence that 74% of surgeries for the back fail. But there is a solution and an end to your suffering. Dr. Fernando Ranella. He's a medical doctor and the founder of the Center for Back Pain Management, where he specializes in the elimination of back pain and sciatica quickly, easily, without surgery or any pain medication whatsoever. Dr. Ranella accepts Medicare and most insurance. He has a location in Delray and one in Fort Lauderdale. Call 561-819-6325. That's 561-819-6325.
Talk health. Talk wealth. Talk politics. Talk 1470. WNN.
The opinions expressed on the following sponsored program are strictly those of the host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors. The content of the following program, including all statements from the hosts and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by the host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program shall not be viewed as substitute for a personal consultation with an attorney. Now, prepare yourself to be informed and entertained by Gus Bravo and Neil Kotze, two AV-rated trial lawyers who have been practicing law for a combined total of nearly 40 years. For the next 30 minutes, they will share their insight and commentary on important legal issues affecting all of us.
Kudos goes out to the Florida legislature for last week passing legislation which now requires funeral homes to bury lawyers at least 12 feet deep as opposed to the 6 feet that everyone else should be buried. When asked why, the president of the Senate said we had to pass this because deep down, lawyers really are good people. Welcome to Attorney Confidential with Gus and Neil. I'm Neil Kotze.
And I'm Gus Bravo. I like that. Actually, for those of you listening, I don't hear these jokes in advance, so the reaction is as natural as it can be. I'm not faking the laugh either. But that was a good one. I like that. Deep down inside, we are good people. Well, welcome again to Attorney Confidential with Gus and Neil. If you want to call in, it's 1-888-565-1470. You can also listen on the iRadio Now app or watch us live on video on usstream.tv. So before we get to the topic of our show, I wanted to, I don't know, Neil, if you had a chance to this weekend. This weekend was a huge sports weekend, especially Saturday night.
Who would have thought that in a weekend where you had horse racing, basketball, and a major championship fight, that the championship fight would come in third.
A distant third, too.
A distant third. The horse race was fantastic. The fight
and the Clippers and the Spurs game was also one of the better.
I think there were more punches thrown in the basketball game. And certainly the jockeys hit the horses a lot more than there were.
That's true. Speaking of the fight, it's funny. I'll give my buddy credit. Mark, if you're listening out there, he asked the question. He called me this morning all upset because he was one of the many people that spent $100 to watch that fight. And so he wanted to know, he goes, let me ask the lawyers, can I get my money back? And so that started thinking, well, yeah, there's ways you can try to file a lawsuit and maybe go and get your money back, but good luck.
Wouldn't the best thing, if he wanted to pay for the plane ticket, why doesn't he just travel, go find a way to see Mayweather and tell him to his face what he thought of the fight, and then his family for the wrongful death lawsuit will get tons of money back. So that may be
that's good advice. Actually,
yeah. So tell him
that'll be $300. Yeah. Thank you very much.
That's only one answer to one question.
But
so that's 100.
That got us thinking. I think obviously we get clients all the time coming up with different creative ways of getting to the courthouse, right? Initiating legal action. So appropriately enough, today's topic is called Pathway to the Courthouse. And I know we have a couple of sample questions. Neil, why don't you kick us off with what do we mean by that?
We've had some shows where we've talked about questions we're commonly asked, and the one on the pathway to the courthouse, well, why can't you just file my lawsuit tomorrow? What does that take? So Gus, you want to take a shot at that?
Well, first of all, you got to hire us. Second of all, we have to gather facts. I mean, it's not that simple. We lawyers have an obligation. We have an ethical obligation to review the evidence, review the facts, and apply the facts to the existing law, and we have a good faith basis to file a lawsuit.
Right, and typically too, although certainly we don't want to take years and years, but there are statutes of limitations on most claims. For example, personal injury in Florida actually has a 4-year statute of limitations.
Except wrongful death.
Right, well, wrongful death is 2.
2 years.
As long as no one died. Typical car accident, broken leg, whatever, is a 4 years. So you want to do your investigation. There's really no rush. And a lot of cases settle pre-suit.
Absolutely.
And so not only a pre-suit investigation, but a pre-suit demand and negotiation process, because that makes the process a lot easier. Once you file the lawsuit, for lack of a better phrase, the butt cheeks pucker up and people people don't. But people,
I just got the visual. That's okay. We're gonna have to move on that one. I think the idea is also you want to give the negotiation, the pre-suit negotiation, a chance,
right?
Because first and foremost, if your lawyer's going to take the case on a contingency, then their percentage is going to jump up after they file a lawsuit. So that means less recovery to the client. But also, more importantly, because we've been on the defense side too, is once you file a lawsuit, you've now forced the hand of the other side. They're going to spend more money defending themselves, and it escalated the problem. So a lot of times a simple phone call from a lawyer to another lawyer or from the client to the prospective defendant may be able to solve the issue much cheaper. One side gets a higher net because they don't have to come out of pocket if you're the plaintiff spending legal fees.
And I think despite the joke at the beginning, lawyers are people too.
No, I'm sorry. It's the other one.
Right. But lawyers are people too, and so sometimes we take things personally, the defendant takes things personally, and if you just fire off a lawsuit without that simple phone call, trying to do some negotiation before you sue, how many times have you had a defense client say to you, why didn't he try? He just sued me.
Right.
And it's the point that you made on the previous show about the other side of the equation is sometimes you can avoid a lawsuit just by apologizing when someone comes to you and confronts you with a wrong, which is now the break for our recent news story.
Right.
We'll do a good transition here where I was going through the news and saw that Doctors Hospital in Coral Gables is now being sued by someone because they threw his leg away. For lack of a that's the big oops. Yeah, apparently it was.
You don't need that, do you?
It was a legitimate amputation. His leg was supposed to be amputated, but instead of incinerating it, which is what they normally do with taking off, they normally burn them. That's the typical process, unless it can be used for medical science with respect to a waiver. Somebody can say, yes, you can use my leg for research. Otherwise, you got to burn it. But they just took it and threw it in the trash, and it was found.
How did they find it?
It was found at a local dump. And the guy at the local a trash dump.
Okay.
It was the police were called in, and it actually had an identifying tag on it. So they go to the guy's house to see if he's still alive, if there were foul play, emotional distress on his family because they didn't know what was going on. Then they find out it's the amputated leg that was supposed to be incinerated at the hospital. So an interesting.
So the lawsuit now seeks what? Recovery of damages for emotional distress?
But apparently the hospital didn't apologize or didn't really explain what happened, and it frustrated the guy enough that he's filing a lawsuit.
Right.
So another example of maybe a little pre-suit discussion process.
Try to nip it in the bud a little bit.
Try to get a leg up on it and try to negotiate it.
Oh, sorry. Go ahead.
Yeah, we're being told that Gus isn't sitting too close to the mic.
No, I think it's too far away.
Right. So, we're in show number 5, but we're still ironing out some kinks. So
I guess no one heard a word I've said up to this point. So that's actually might be a good thing.
I do the same thing in the
office. Might improve our ratings.
Exactly.
Actually. So we got through the first point. We have several points. What's your next question?
Well, the next question is, why does it take so long to have my day in
And by the way, this is not your question. This is you playing the role of a client.
Right. Well, not that I'd ever hire you to represent me, but I'll try to play the role.
I can't be saying.
No. Actually, it would be very comfortable having you as my lawyer. In fact, I think I asked you to do that once, and it just never came to fruition. But the next question is, and both of these questions actually relate to people really wanting to move forward quickly, and it's why does it take 1 to 2 years for me to see longer? And the speech I like to give to clients is that the wheels of justice turn slowly. Our goal is just to make sure they don't run over our clients. So you have to.
I've heard that. You stole that from somebody.
You've heard me say that many a time. Actually, that's a quote derived from a Star Trek episode, if there are any Trekkers out there listening. But it is. That's where I stole that.
You're the only one in the room.
Well, I'm the only one old enough to remember the original series.
And I think what clients have to understand is the process takes time because, first of all, the court system is backlogged. There's a lot of filings. I mean, to give you an example, I think last year in Miami-Dade County in civil court, I think there were over 60,000 new cases filed. A lot of them, obviously, mortgage foreclosure. So the court system is backlogged. But also you have a scenario that, I mean, clients don't realize lawyers have other cases, and so we're working diligently on numerous cases, and these things take time.
And the other issue is it's not just you file a case and you go to trial. There's the whole discovery process, which a lot of people, if you're not a lawyer, aren't familiar with. There's depositions. There's what we call interrogatories, where you ask written questions, requests for documents.
And each of these steps has built-in time frames. For instance, you ask somebody for documents, they get 30 days, and then you'll get them the courtesy extension, and then you may do another second and third wave of requests. So you can see how something can take several years. I mean, we've had cases dating back, still active, 2005, 2006.
I have a case right now that has a 2005 filing date.
Right, and sometimes it's completely out of our control because the judges just don't have time to hear important hearings because, again, they're backlogged. Right. So I know you have a hearing coming up that just got switched from June, and the next available date was September.
Yeah, and so...
and if you don't take that one, you may be looking at 2016.
Right, so sometimes, and hearings, for those of you that aren't lawyers, is there are issues that come up during the case in which the lawyers, believe it or not, actually disagree on how to proceed, so everything gets put on hold while the lawyers can go in front of the judge, and we have hearing court, we have motion court every morning. In fact, some judges refer to motion court in the morning as breakfast with whiners. You've never heard that?
Speaking of which, we have some slides. I've skipped the first one, the Pacquiao-Mayweather one. So I'm going to ask him to put up the second slide, which is the courthouse.
That's for those of you, the 5 people watching the video live, and those of you that get to watch it later can see the slide.
So let me explain this slide. This is a picture of
a Starbucks.
Yeah, no, but besides
there's a courthouse behind it. Oh, I'm sorry.
Do you recognize that courthouse?
I do. That's the Miami-Dade courthouse.
Right, and so what I like about this picture is, first of all, it's the Miami-Dade County Courthouse, which, if you're a Dragnet fan, it kind of looks a lot like the L.A. County Courthouse, right, from the entrance. It's an old, kind of, I forget how many, it looks like 10, 15 stories. But there's also a Starbucks right there. So it shows the combination of the old and the new. Of course, you're going to have a Starbucks at every corner, especially at the corner right before the courthouse. Now, what's interesting about this, and you pointed this out, Neil, I got this picture from Google, from the images. There's a way you can actually download images that are free to use, not only for your personal use, but also for commercial use. You just have to do an advanced option feature on Google, and it'll let you, because there's some copyright issues with some photographs that we think are fair game, right?
Free legal advice to those of you: if you just download pictures from the internet and use them in presentations, you may be violating copyright law.
Exactly.
And there are trolls out there, and I'm not talking about the little short furry people that sit under bridges. There are trolls. They're called patent trolls, copyright trolls, that will actually search for people who have gone through the internet and pulled pictures. They'll notify the person who owns the picture, and you'll get a nasty letter and a lawsuit that, frankly, you can't defend because you legitimately downloaded a picture of the internet you shouldn't have.
And the way, again, to avoid it is Google, in its infinite wisdom, has a feature where you can search only for images that are free to use. And some of them, not only can you use commercially, but they even allow you to modify them, which I thought was an interesting feature. So we're coming up, I think, on our break now. So in the second half of the show, we're going to continue talking about a pathway to the courthouse. But so far we've talked about, I think, gone through a couple of the questions. I know we have several other questions. And for those of you listening, feel free to call 888-565-1470. You're listening to Attorney Confidential with Gus and Neil.
Attorney Confidential with Gus and Neil is being brought to you by the law offices of Neil D. Codsing and Bravo Law. Bravo Law is a business litigation firm known for providing common sense solutions to small businesses and individuals throughout South Florida. Mr. Bravo is rated AV by Martindale-Hubbell and Superb by ABVO, the highest ratings available from these two entities. The law offices of Neil D. Codsey is the litigation boutique with offices in Broward and Miami-Dade counties. Mr. Codsey is a veteran trial lawyer with nearly 25 years of jury trial experience. He is also a two-time recipient of the South Florida Daily Business Review's Most Effective Lawyer Award, a recipient of numerous awards for providing pro bono legal services, and has been recognized by the National Law Council. Call our office, 786-464-0841 or 954-790-6711 and get informed.
Welcome back to Attorney Confidential with Gus and Neil. Today's topic is pathway to courthouse or pathway to the courthouse. For those of you just tuning in, feel free to call us at 888-565-1470. We'll be happy to tap dance around any legal questions you may have. But Neil, I think before
you do the tap dancing, I don't want to dent the floor.
I know we have a couple of more questions to get through. These are the questions that we routinely hear from clients when it comes to the court system.
Right.
So what's next one on the list?
Because, again, we're talking about people who have cases that they want to file a lawsuit on, and you get these common questions such as, we looked at the plaintiff's side, the people that want to file. I'm going to shift gears now, actually, to what we hear from the people who are sued. Every time someone gets sued, they hire their lawyer and they say, this is a frivolous lawsuit. We should be able to get it dismissed.
Yes.
I can't imagine I have to pay you for more than 2 hours of your time. Just get it dismissed.
This is a simple case. You should be able to get it dismissed, no problem.
And the problem, and maybe it is a problem with our judicial system, is that it is very difficult to prove that a lawsuit is frivolous. In fact, I could file a lawsuit against Gus tomorrow claiming that he punched me in the nose and that I was injured. Absent there being witnesses to the exact time I put in the complaint, or people that say Gus wasn't even in that city that day, that lawsuit gets to proceed through discovery and gets to proceed through depositions, and it's my word against his. And if I were the type of person that were willing to make up a story, that's a very hard story to impeach. A simple case like that does not necessarily get dismissed. It goes all the way to a jury.
Well, yeah, because it's your word against mine.
Right.
Even though that
it's
would
he
be
said, she said.
Completely one-sided. No, definitely not in that relationship. Right. But it's all kidding aside. It becomes a decision for what we call the trier of fact. It usually is the jury. Sometimes when it's a bench trial, it would be obviously the judge. But these are the kind of cases that it's a he said, she said that gets resolved further down the litigation.
And how many
line.
times do we dive into a lawsuit as an attorney and see that the facts just aren't, there's no black or white.
Right.
I think in prior shows I've used the car accident example of where one person runs a red light at 10 miles an hour over the speed limit and hits somebody else, and then they get sued. And then what you find out from the plaintiff who says this should be a slam dunk is the plaintiff had a beer before he got in his car. So the person who got hit was drinking, or the person who got hit was also speeding.
So now the facts get a little bit cloudier.
So there's a question there as to whether maybe they could have avoided the accident, even though the first driver was clearly at fault. I mean, we could come up with hypotheticals till the cows come home.
There are rules in the system and rules of procedure and statutes in place to try to prevent and serve as a safety net for frivolous lawsuits. There are some mechanisms where not only if the frivolous lawsuit gets filed, is the client could be on the hook for sanctions and fees, but so could the lawyer. So it gets back to the original point of why can't you file tomorrow? Well, we got to do our due diligence.
We have to protect our own license.
But even then, as you pointed out, the threshold is very high to get something to rise to a level of frivolity necessary in order to get sanctions. So that, I guess the logic behind it is, we want to make the gates to the courthouse as broad and as easily accessible as possible.
Right.
And then eventually through time, those cases will get, eventually filtered away. But what that means is it means your ridiculous scenario earlier, me punching you in the nose.
Right. Because you would never do that. Because you're afraid of me.
I would kick you first. I was a soccer player.
Exactly.
But even that kind of case would have to linger in the court system for a while, because we'd have to take your deposition, mine, and exchanging the document, the discovery, and all these steps. And then eventually I may get tired of paying a lawyer to defend something ridiculous, and I may just throw some money your way just to make it go away, because it's a very stressful situation, because I may want to kick you again.
Right. Exactly. But that's the problem. I mean, and when you're dealing with cases, let's face it, there are people out there that are willing to fabricate testimony and not tell the truth. And it's hard for a lawyer to see through that sometimes. I mean, sometimes things that don't sound commonsensical are really what did happen, and vice versa.
And but and that's the extreme. You know, those are the extreme. Those are the outliers and stuff. I mean, we're talking about, like you said earlier, most cases that walk through the door, or any lawyer gets on any given day. There are a lot of different shades of gray. It's not black and white. You hear one version, but then you're prepared to hear the other version, and you see why they can't come to terms, because both sides feel very strongly about their position. So those things are not going to get resolved easily. That's why you can't just make it go away that quickly. What's the next question you have?
The next one transitions well, because here we are talking about how you're going to have to develop your evidence to prove or disprove. And then another common question we get is, well, why can't I just hide the ball? Why do I have to answer all these questions?
Why do I have to show them my
cards? Why can't I just force them to prove it? Why do they get to ask me what happened? Shouldn't they have to prove it? Well, in the criminal context, a criminal defendant has that right. But in the civil context, you have the right to discover the evidence, because every courtroom we try cases in has a sign behind the judge, and is a sign that those of us who are trial lawyers, all joking aside, firmly believe and follow. And it says, "We who labor here seek only the truth." And that's important. And so the parties are given the opportunity to actually develop and learn the evidence. And sometimes you file a lawsuit not knowing all the evidence, because you don't know what the other side has done. I mean, I'll give you an example from all the tobacco cases. When people sue the tobacco industry, they don't know about all these internal documents that the industry has, and maybe we'll go into some of those on a different show.
Secret memos.
Right, there's the secret files that some plaintiffs' lawyers used to refer to them. But there's no way for a smoker to know that. So you file your lawsuit, and in discovery, you get those documents. And that's why you see the 60 Minutes series shows and all the things that were on about those documents.
And you know what's complicated matters now even more so is social media, because now, for instance, you have that not only your real world life, but now folks are putting all sorts of a treasure trove of information on social media. So if you're a plaintiff seeking some kind of emotional distress, the person with the leg, right? I mean, what if now you go to this Facebook account in the doctor's hospital case, and you see that they were throwing these big parties, and he's claiming that he's all emotionally distressed.
Or he posted on his Facebook page, "Can you believe what the hospital did? This is the funniest thing that's ever happened to me." Yet he's suing for emotional distress.
And people are very honest when they reveal a lot on social media.
I'll date myself as much as you like to.
You're going to log into Google.
But emails. When I started practicing law, there weren't emails. Emails were internal. They were not. You didn't send
pigeons.
Emails. Yeah. They were, yes, we would put our notes in pigeons, but faxes were the popular thing. But emails, people get so casual in emails now, and we get what's called e-discovery. We won a big case involving a hurricane. Back in 2004, you remember Charlie, Francis, and Gene went through a hotel chain in Daytona, and we were trying this case. Right after Charlie hit, they had $25 million in damage. Right after Francis hit, they had $25 million in damage. Then Gene hit, and everybody's quiet. And we have adjusters on the ground. No one is claiming any damage. 1 year and 364 days later, the statute on the policy was 2 years. They go, "Oh, wait, Gene, $25 million in damage." And it was very hard for us to start disproving it because we didn't do the documentation. But when we uncovered the emails between the hotel owners saying, "Thank God we didn't get much damage from Gene. We dodged a bullet from Gene." I had a host of emails to show the jury where people were actually saying things contrary to what they were alleging.
And that dovetails nicely to before why it takes so long, because it takes time to go through that. First of all, get access to that, because they will fight you naturally. So the other side in producing that information, you'll get it. You have to comb through it, comb the desert, and then what you have to do is then take depositions and follow through. it's not always there's not always a clear smoking gun, but you have
Right.
this whole emails, social media, all these things play a role.
And even in a case that's not that complex now, because of emails and the data that you're going to get, sometimes it's worth looking for emails.
Right.
It's in car accident cases now. Everybody wants to get phone records to see if the person that
Was
was
texting.
negligent was texting or on the phone
Well, I
during
heard
the
the
accident.
case in Miami. I don't know if you read the papers. There was a girl who's accused of manslaughter or murder on trial, and she texted, "I'm drunk, about to die," or something like that, thanks to you. And then literally minutes later, she smashed the car into some kind of wall, and the passenger died. And so these things are there. That we are now, the digital imprints are recorded
Right.
everywhere. Wherever we go, it follows us. So these are things that you have to reveal to the other side. I mean, it's only fair. Now, there are limitations. They can't go on a fishing expedition, as we like to say it. I
Right.
mean, if you're suing for a breach of contract, who cares what I did on my vacations, or who cares, what about your, anything about your love life? It has nothing to do with it. But obviously, we know the other side will try to get that information and try to embarrass you and whatnot. So it looks like we have 3 minutes left. I think we have time to get back to our last question.
Right. What one was, are there quicker ways to get this over with? We hear a lot because once
Yeah,
we're in
write a
that
check.
heated litigation, if you're the defendant, it's write a check. If you're the plaintiff, there's what we call alternative dispute resolution.
Right.
And we will probably devote a whole show to that topic, because what I mean by ADR, or alternative dispute resolution, there's arbitration, there's mediation, there's summary jury trials, which are a very interesting concept. We do a lot of those in the West Palm Courthouse, where you just bring in a smaller jury, you get a day to put your case on, you get a presiding judge, but it's
Those could
limited
be
evidence.
extremely effective
Right.
tools. I'm a huge proponent of
And there's focus groups,
mediations and
yeah.
arbitrations, because I think, again, the judicial system is so clogged that we find an alternative medium to have our day. It may not be in a courthouse, but it could be in a conference room, and it still is as effective, because at the end of the day, the parties don't care who decides, as long as someone writes a check and the other guy's willing to accept it and go away.
Right, and that's one of the reasons that such a high percentage of cases settle, because
Right.
of these alternative forms of dispute resolution. So for those of you in litigation, just like the pharmaceutical companies are advertising all this medicine you need to ask your doctor about, if you're in litigation, ask your lawyer about what the alternative dispute resolution, if you've been active very long.
And that's something we'll probably cover a lot more in detail at some
Right.
later show. But for now, we're coming to a close. So now it's the time for you to give your 10-second takeaway, Neil.
My 10-second takeaway is that litigation is complicated regardless of how simple the case is. So the pathway to the courthouse is never a simple follow the yellow brick road path. It's a path that has twists and turns and jagged edges, and it's a path that a skilled lawyer can take you through, but it's not a simple path.
Okay. And I'll ask the last slide to be put up for our closing comments. And this is the one of Michael Jordan. There it is.
Fellow Tar Heel.
Yes, I did it in your honor. So this is our deep thought, closing deep thought of the day. This comes from the one and only Michael Jordan, who said, "I've missed more than 9,000 shots in my career. I've lost almost 300 games. 26 times I've been trusted to take the game-winning shot and missed. I've failed over and over and over again in my life. And that is why I succeed." Michael Jordan.
Very profound, because the pathway to success is laden with mistakes that you have to learn
You always
to correct.
hijack
I
the
have
quotes.
to hijack the quote because,
Anyways, all right, tune again next week to Attorney Confidential with Gus and Neil.
You have been listening to Attorney Confidential with Gus Bravo and Neil Kotze, two rated AV trial attorneys with over 40 years of experience. Tune in next week for another episode of entertainment, insight, and just plain fun. That's Monday, 6 p.m. on WNN, 1470 AM. See you next Monday for more Attorney Confidential.